Welcome to the Construction Industry Federation COVID-19 Subcontractors FAQ. My name is Larry Fenelon. I'm a partner in Le Mans Solicitors. We're a law firm that specialise in construction disputes. So we're going to be looking at two forms of contract today as part of this webinar. The first is the public sector and the second is private sector. In respect to public sector, it's going to be CIF agreement and conditions of subcontract domestic for use with public works contracts, October 2016, and then for private, it's going to be the CIF subcontract for use with RAI main contract form, 5th edition, October 1989. I would like to emphasise to you that it is critical that you review your own subcontracts because they will inevitably be amended. Almost always in any significant job, there will be wholesale amendments to the standard forms of subcontract. So the first question we have to answer today as part of this webinar is the payment is due to the subcontractor. There's been no response from the main contractor. The payment's been withheld. What should the subcontractor do? Under the Construction Contracts Act 2013, there is a provision within that act which says that the payment has to be made within 21 days of the payment claim notice being served. You should note that the Construction Contracts Act 2013 is effective for all construction contracts post-June 2016. It doesn't matter whether your contract is written or oral, this provision still applies. So, first question you should be asking yourself is, have we lodged a payment claim notice? Yes. Have we received any response, good, bad, or indifferent, within 21 days? If after 21 days you haven't received any payment, then a payment dispute arises. Your next steps are going to be either suspension or adjudication, but at that stage, I would certainly not recommend anyone going solo. I would firstly seek advice from CIF, and secondly, I would seek some professional advice. I have seen instances where subcontractors go solo and they really make a bags of it, and then they will call us in to rectify things halfway through the adjudication, which is not ideal. So technically speaking, we should ask ourselves, what is a payment dispute? Well, the standard form of public works contract helps us out at clause 1A, which states that it's a dispute relating to payment. Not all that helpful, but I hope you get the picture. Historical litigation tells us what doesn't amount to a payment dispute. So for example, extensions of time applications cannot be referred to adjudication, nor can disputes over specificity of works, requirements or drawings, or indeed disputes over delay or misrepresentation or nuisance claims. The Construction Contracts Act 2013 confirms that a subcontractor has a right to refer any payment dispute to adjudication at any time. And that is effective from any contract entered into in a construction and industry environment from the 25th of July 2016, whether or not that contract is in writing. So it doesn't matter if your contract is in writing or not. It doesn't matter if your contract is in writing but doesn't refer to adjudication. You still have the right to go to adjudication at any time. And clause 13A is the standard form of public works subcontract confers that right. Traditionally, the types of claims that went to adjudication were final account squabbles, claims for adjustment to contract sum which hadn't been resolved, or gaps in what you've claimed and what you were actually paid. But in the straitened times we live in, it's now relating to no responses from contractors in respect of payment claims. Okay, so question 2. Am I expected to work if there's a stay-at-home order in place and I have not received confirmation that the works are deemed to be essential services, even after I've sought this clarification? Okay, to answer this question, we're going to have a look at a couple of definitions that only lawyers would bother themselves looking at. So the first one is legal requirement. What does it mean? Legal requirement is a law, a decision of the court or European court, or a requirement of any person having authority in connection with the works under any law. Law itself is defined as enactments and statutory instruments, regulations, directives. Enactment includes an act or statutory instrument, and a statutory instrument is very broadly defined as any regulation, order, rule, bylaw, warrant, license, direction, notice, guideline, or any other document that's issued or created under any act. Okay, so the President signed the emergency measures in public interest, which is the COVID-19 2020 Act on the 20th of March 2020. So the Act is undoubtedly an enactment, which is in turn a law as defined under the contract. The Act was enacted to legalise a variety of emergency measures for the state's apparatus to protect the safety of the public and to arrest the spread of the COVID-19 disease, and the preamble of the Act reflects that. So in front of that Act, the government published guidelines to restrict work and work in the workplace, and it also provided a list of essential service providers. So inherent in that Act was the restriction on travel by members of the public and restriction to the work in the workplace. The list of essential services did provide an exception for construction, and the guidelines for the non-essential services basically said that there were 3 subcategories of construction that you could do under the COVID-19 restrictions. Under the government guidelines, as it currently stands, there are 3 essential categories of construction activity. It's basically where you're either constructing COVID-related infrastructure, or whether you're doing emergency repairs of a domestic nature, or whether you're doing civil works repairs of a domestic nature. Now, it's fair to say that these lists of essential works are fluid and will inevitably change, and certainly are anticipated to change as construction activity is permitted to restart. So now we know that construction activity, unless it falls within those 3 very narrow subcategories, is illegal under the current restriction measures. Also important to know that the provisions under both RIAI and PwC contracts confirm that the contractor and the subcontractor shall comply with legal requirements and the law when performing the contract. So it's immaterial whether you haven't received any official letter from the contractor or the employer's representative as to whether you are permitted or not to work on site. You're not obliged to return to site until there's further authorisation from the government. The RIAI contract confers further rights because it says the contractor and subcontractor at clause 18 shall not be guilty of any act or omission which constitutes a breach or infringement of any statute or any legally binding bylaw, regulation, order, rule made under the same or by any local or public or competent authority. Basically, you won't be in breach of the law if you're complying with the law. Okay, question 3. What should a subcontractor do if the site is not available but no formal instruction has been received from the main contractor? To answer this question, we're going to have a look at a couple of the terms of the standard form of main contract and subcontract and public works contracts. So clause 2.2 we know states that the main contractor has to comply with the law and legal requirements. And we know that that means the recent act that was passed and the guidelines and the restrictions that flow from the act. We also know that clause 1a of the subcontract confirms that the subcontractor's personnel includes their employees and subcontractors. We know that clause 4b1 of the subcontract states that the subcontractor shall comply with the instructions of the contractor. And we know that clause 4a of the subcontract states that the contractor and the subcontractor should provide reciprocal cooperation and support for the subcontractor's purposes. So we've already looked at legal requirements and the law and enactment and statutory instruments. So we know that there's a general obligation to comply with the law and acts and guidelines and directions and notices that flow from those acts. So most subcontractors haven't received any instruction from the contractor in relation to the site closure, and I think nor likely are they going to. So what do they do in this lacuna? They don't know where they stand. I think that the subcontractor should be writing to the contractor looking for an instruction. I think, however, it's unlikely the contractor is going to give that instruction because they in turn are waiting on the employer to do the right thing to suspend the works. In my view, clause 454 of the main contract, standard form main contract public works, states that if it's impossible to carry the works or it's contrary to law, the employer should suspend the works. That hasn't happened in most instances, and I think that's illegal. So why are employers refusing to suspend works? Because they know that this will enable the contractor to claim for compensation events under public works contracts under Schedule 1K Item 3, if that's the case, and that's really what they're seeking to avoid. So I think that the subcontractor should be in public works contracts be acting as if the employer has suspended works and serve a notice of delay and for a compensation event also. So turning to the RIAI contract, clause 20C4 confirms that where the contractor suspends works, the subcontractor is entitled to determine or end the contract. The question really is what happens on the termination of the contract. The subcontractor is entitled to be paid for the works carried out to date, for the materials on site, and can further exercise a lien over materials not yet fixed to the site. Furthermore, clause 21 affords the subcontractor further reliefs should the main contract be suspended. So question 4, how should a subcontractor deal with delays, extensions of time and LADs under the contracts? I think the first thing to say is the risk of LADs for a subcontractor in respect of a COVID-19 lockdown where the site has been shut is very remote indeed. So just to alleviate any concerns that you may have. Nonetheless, to be on the safe side, I would strongly recommend that all subcontractors would serve the usual notice of a delay event under the standard form of public works contract under clause 9C of that contract, and that is to be done within 10 days of becoming aware of the event. As you know, a delay event under scheduled part 1K of the main contract in the public works contract confirms that delay caused by public authority is not a compensation event. So this is all about steering your claim to enable you to claim not only time under the programme but also a compensation by way of an adjustment to a contract sum. That's not as easy as it is said. So just to remind you, there's a 3-stage process in serving notice under the contract. Firstly, your initial notice within 10 days. Then within further 20 days, you have to give further details in terms of calculations of delays, or indeed the calculations you have relying on for the adjustment to the contract sum, and then updated details every 30 days thereafter. The Office of Government Procurement published a note on the 14th of April 2020 entitled Update 1 to the Note on Procurement and Contractual Matters Associated with COVID-19 Response Matters. They obviously differentiate between essential and non-essential works at section 321 and section 322 of that note. They also refer to the fact that the usual notices in respect of notification and management of delay are to be served as per the public works contracts. They point to a delay event under item 15 of the scheduled part 1K, which is delayed to the works caused by the order or other act of a court or other public authority exercising authority under law that did not arise as a result of or in connection with an act, omission or breach of legal requirements of a contractor or the contractor's personnel, or in breach of the contract by the contractor. So essentially really what the government is stating is that highlighting that this is effectively COVID-19 shutdown of site amounts to a delay event under item 15 of scheduled part 1K of the contract, and not item 3, which is where the works are suspended by the employer. The government have been very careful not to confirm that this is a shutdown by the employer. So there is an appropriate extension that can be granted for delay due to an order or other act of a court or other public authority. And I think the government are really ceding that position, and they're also saying that the performance period for a task may be extended by an amount corresponding to any delay to the completion of the investigation due to any order or act of a court or other public authority. So in order to calculate an extension of time, the delay should be treated as having commenced on the date of the site closure following the publication of public health measures on the 28th of March 2020. In terms of the cost, the government is stating that they're stating that under the public works contracts, the contractor and subsequently the subcontractor is not entitled to recover any adjustment to the contract sum as a result of the delays caused by the COVID-19 shutdown. And I have a particular view on this. I think that if the employers were obliged, as I feel they should have been, to suspend the works, then that would have legitimised a compensation event under the contract. And I think there's lots of public spats about who actually closed the site between the state as the client and the contractors working on those sites. So this publication also confirms that without any admission of liability or responsibility, the employer, the state in this instance, is under public works contracts prepared to make what's known as an ex gratia payment for the period that the site was closed. Now, in terms of what do you get paid for, there are certain permissible items of contractors' preliminaries unavoidably incurred and reasonable and vouched, which is to be reviewed on a project by project basis with individual contractors by the employer or any other party nominated by the employer, including the employer's representative. Examples of permissible preliminary costs include costs associated with insurance premiums, maintaining site security during the closure, the performance of the ongoing health and safety obligations in relation to the closed site. It does require vouching materials, so think of invoices and the like, and not just cost breakdowns. And the determination of that ex gratia payment shall remain at the, I suppose, the prerogative of the employer, which gives the state all the power in these instances. So you can see a lot of contractors opting for this ex gratia payment instead of toughing it out and starting legal action against the state, who are their employers, on the basis that this should have been an employer suspension of works under item 3 of Schedule 1K of the main contract. So the ex gratia payment, if you want to reclaim it, you're going to have to set out the parties and the project, the amount determined by the employer to be paid, the headings of the costs, and that the agreement is supplemental to the contract for the undertaking of the works. So there is a formula for calculating the ex gratia payment, and you should be really having a look at the publication, which is known as the Update 1 to Note on Procurement and Contractual Matters associated with COVID-19 response measures. Hardly rolls off the tongue, and that is a publication of the Office of Government Procurement and it's dated the 14th of April 2020. Finally, I should just say, under the RIAI Standard Formal Subcontract 1989 edition, Clause 7b states that there is, obviously you have to serve notice of delay under that contract also. Question 5, what are the potential additional costs that can arise and how to claim them as a subcontractor? Many of you will have observed Minister for Finance Pascal Donohue's recent announcement that the state was going to cover the cost of maintaining sites closed as a result of the coronavirus lockdown. I've left up a hyperlink there to the Irish Times article. It's interesting to note what they're saying. It's all a little bit vague, to be honest with you. The state is to cover agreed reasonable non-pay fixed costs incurred during the time that the sites are closed, and the time period is very specific. It runs from the 12th of April to the 4th of May until there's a further review from the state, and it will be determined as a daily rate with reference to the contractor's fixed costs as set out in their tender, and on a case-by-case basis, and hopefully there's a trickle-down effect for subcontractors in that regard as well. However, it does exclude labour, and it does exclude costs arising from a delay event. And I think what the Minister is trying to do here is to negotiate for the state a better deal, because it's quite clear under Clause 454 of the main contract, as I've stated earlier in this webinar, that the employer ought to have suspended works, but that would obviously trigger a compensation event occurring under item 3 of part 1K of the schedule to the contract. So a delay caused by public authority obviously doesn't equate to a compensation event under item 15 of part 1K of the schedule to the main contract, and that's really the bottom line here. So the only way that a subcontractor is going to be able to claim compensation under public works contracts for the delay caused by the coronavirus lockdown is to assume that the employer ought to have, under Clause 454 of the main contract, suspended works, and that would then trigger item 3 under our schedule, part 1K of the schedule to the contract. So the subcontractor should seek an instruction from the contractor. The contractor will probably not reply to that, but the subcontractor should nonetheless state in its letter that it is assuming that this work should have been suspended under Clause 454 of the contract, and consequently that they're entitled to claim a delay and compensation event and should serve the appropriate notice under the contract. That's 9C and 10A of the standard form of public works subcontract. I think the real issue is going to be when subcontractors return to work. They will undoubtedly face additional costs, including increased supervisory from shift work. They'll have less labour. The subcontractors may not be available to them, which means less productivity, more supervision, increased premium for performance bond and other like costs. So they're going to face increased cost and potential delay, which may delay the main contract programme. I'll talk about that a little bit later, but that is certainly an issue that most subcontractors are going to have to address, and I think they're going to have to address that by way of a variation to the contract terms. Just very briefly on the RAAI, clause 24 talks about legislative enactments, and it certainly could be argued by the subcontractor that the emergency measures constitute variations within the meaning of clause 24 of the subcontract, which would entitle the subcontractor to seek an adjustment to the subcontract sum. So question 6 is to advise subcontractors who are starting a new project under what circumstances should they start, and what should be requested from the main contractor under the pandemic conditions, and how to cater for those risks. So lots of questions in that question. Our strong advice here is to vary the terms of the contract by inserting a new, what we're calling a COVID clause, and that really isn't just a one-liner. It's a series of clauses to cover off the following issues, such as, if the subcontract works are suspended, then there is a stoppage period, and that the date of completion of the subcontract works is obviously to be suspended until the stoppage ceases, to cover off subcontractors being entitled to an extension of time from the number of days of the stoppage, and to cater for increased costs of supply chain, shortage of human resources, site supervision costs, etc. That needs to be catered for, because there is no ability to do so under the standard form of public works contract, and also remobilising costs for labour shortage. There's labour shortage and supply chain difficulties, and indeed to cater for issues such as the insolvency of the subcontractor. That COVID clause should also include a provision that allows the subcontractor to terminate if they're unable to meet their obligations under the contract as a consequence of all of these additional costs, labour and supply chain shortages and delays. And should also cater for acceleration, because undoubtedly the contractor will want to accelerate the programme when they return and remobilise, and there may not be an ability by the subcontractor to meet that acceleration. We need to address that, otherwise they're obliged to meet the acceleration. If there was no variation of the contract terms, there is an obligation to comply with contractors' instructions, unless those instructions are unreasonable. And determining reasonableness is really a matter for lawyers to fight over, which nobody wants to happen. It should also cater for non-compliance with the new COVID standard operating procedures on site. If there's a casual attitude to safety and health on site by the contractor or the contractor's personnel, then there should be obviously a right of the subcontractor to suspend work on 24 hours notice without any penalty imposed, and indeed to address any issues of non-payment. So you can draft all of these things all you like. It's ultimately going to be a matter of negotiation, and I think the prudent subcontractor will be working on their COVID clauses to cater for all of these additional costs and delays, because if you don't, the reality is there's going to be a threat of liquidated and ascertained damages being faced by subcontractors as a result. They will delay the programme inevitably, and they won't be able to point to anyone but themselves as a result of that. And indeed, they may not be able to fulfil the terms of the contract simply because their subcontractors may have gone east of the Danube and aren't returning anytime soon. So look, all of that is in play, and any new contracts, I certainly wouldn't be entering into any of those unless there was a COVID clause to cover them. I've been requested to return to work without adequate staff. What do I do under the contract if the pandemic persists? To answer question 7, I think two things are very likely. Firstly, access to subcontractors is going to be severely diminished on the return and remobilisation, and that's because gangs of subcontractors east of the Danube have returned home, much like everyone else has around the world. There might be indeed travel restrictions disabling them from returning to Ireland to continue their work under the subcontract. So I think this is highly likely for a lot of subcontractors, particularly the more specialist types. And the second, I think that's quite likely, is that this may not be the only lockdown within 2020. I think if we turn to other countries that have had a head start in this whole saga, such as Singapore, they have been locked down for a second time and will be locked down to June. So this may not be the only lockdown within 2020. So how do you protect yourself? I think in the first instance, if you are unlikely to have sufficient labour, then you need to serve a notice of a delay event under both contracts, both PwC and RAI. There is no exemption to that. And don't forget, if there's any cause of delay to the main contract programme by any reason whatsoever, then you're obliged to serve a notice of a delay event and seek an extension of time under that. I think you should also be seeking to amend the terms of the contract as per the slides I've just talked about in terms of COVID clauses. There is provision to terminate, so a subcontractor is entitled to suspend works where the employer suspends the works for more than 3 months and it's impossible for the subcontractor to fulfill its obligations under the contract, then it's entitled to terminate. And termination, although it's very drastic, may be a better option than facing hundreds of thousands, if not millions, in LADs that will bring the company under. And the contract should also be terminated by the contractor, but there could be a claim for consequential loss, undoubtedly, if the contractor has to bring in another subcontractor at an additional higher cost and has lost time as a consequence, then I think they will certainly pursue the subcontractor for that. And finally, under the RAI clause 20C4, that enables the subcontractor to terminate or determine the subcontract if the contractor suspends the works, and the provisions of clause 20D apply in that such determination. And linked to the previous question 8 is, what if I return to work and I can supply the material as the supplier is closed in Ireland or another country and I can't open an account with another supplier? So I think in answer to this question, I think the subcontractor should be establishing the position now in terms of what its supply chain is like. It's likely that the government may lift restrictions, certainly in construction workplaces, in early May, and now is the time to be establishing what the supply chain is like. If you become aware of any delay to your supply chain, I think you should be serving notice now. Just because the site is closed doesn't mean the contract isn't operational. The contract is still operational unless it's determined or terminated. So you have an obligation now to serve a notice of a delay event as soon as you become aware of any risk of delay to your supply chain. Third thing is, I think you're under an obligation to mitigate loss. And that means that if you cannot get your normal equipment and material from a supplier in this country or outside the country, then you have to show attempts to engage an alternative supplier. And so that is an obligation to mitigate and to evidence that by attempts of emails and the like. The fourth thing is, I think you should be engaging with the design team to see if you can identify an alternative product if supply is made easier as a consequence. The fifth thing is, although it's unlikely, is perhaps to engage with the contractor or indeed the employer to act as a surety if you had to open up a new account with a new supplier without any credit history for that supplier to work with. And then finally, I think you should work all of these provisions into a new COVID clause, as I've advised previously. I think this is a matter of negotiation, and I think it should be taken very seriously. Because going forward, whether you enter into new contracts or for your existing contracts, these issues will arise. And until there's a vaccine, I think we'll face a lot of constraint in terms of supply chain and labour. So question 10 is, materials are held for the purpose of the job and I can't pay a supplier as the subcontractor hasn't been paid by the main contractor. So I think the subcontractor has some leverage here in advance of mobilisation. I think the contractor will be gung-ho to get going. The subcontractor should firstly ratchet things up in terms of pressure with the contractor. In the first instance, they should be writing to the contractor, advising that there will be delay to supply chain and to the subcontract works being carried out, which would jeopardise the main contract programme unless they are paid, so that they can in turn pay the supplier. And the second thing is they can serve a notice of suspension in advance of remobilisation, which will obviously get the attention of the contractor. Another thing they should be doing is mitigating loss by considering a payment plan with the supplier. And of course, to cover themselves under the programme and against LADs, they should be serving a notice of a delay event under public works contracts and indeed under private contracts. The fourth thing is obviously adjudication is available to them, and of course this is then a payment dispute just because you owe money to the supplier. But if the cause of that is because the contractor hasn't paid you, then obviously you have adjudication available to you. So question 11 and 12 are linked. Subcontractor has left plant on site. Is it safe? Where does liability lie? And is insurance affected? And question 12 is the subcontractor's materials have been left on site, and is it safe? What if they get damaged? So these are obviously very valid concerns. There has been a reported surge in theft on sites during the lockdown. I think site security is obviously the responsibility of the contractor. So the contractor is entitled to costs of security by the employer under the recent pronouncement by the Minister for Finance on the 14th of April under public works contracts. So recovery and damage is really a matter for insurance. I'd be very surprised if there wasn't a construction all risk policy in place on the site, which is the policyholder is obviously the employer, and that tends to insure all property from any damage caused whatsoever. However, there are a couple of exceptions and caveats, as you would expect from any insurance policy. So subcontractors are generally an insured party under the CIR policy, and of course subcontractors have their own policy in place for materials and equipment. If there is no CIR policy, then the subcontractor should seek recovery under the contractor's policy of insurance. And if the contractor has no policy of insurance, then they can make a claim under their own policy of insurance. So there's a trickle-down effect, and of course there should be a letter setting out the liability of the contractor to any loss or damage. So if you have any concerns, you should be setting that letter out now, or if you have any claim to make, you should be asking for the contractor to compensate you. It's highly likely the contractor will ignore or refuse to do so, and then you should pursue the claim under the various insurance policies that I've outlined in this slide. So under the 1989 RAI standard form of subcontract, clause 5b obliges the contractor to take out an all risks policy covering works and ancillary items. Now, ancillary items mean temporary works and all unfixed materials and goods intended for the subcontract works, except temporary buildings, plant, tools and equipment owned or hired by the subcontractor. Clause 19 is quite important. It says plant, tools, equipment or other property belonging to the subcontractor are the sole risk of the subcontractor, and any loss or damage caused shall be the sole liability of the subcontractor. However, in light of lockdown and in light of the fact that the contractor is solely responsible for the security of the site, I'm not sure that clause 19 would or could be relied on by the contractor if there was loss or damage caused to the plant and equipment of the subcontractor on site while the site is locked down. So that completes our webinar. I'd like to thank you very much for your attention. I'd like to thank CIF, and in particular to Sean Downey, Director in Specialist Contracting, and Gillian Ross, Executive in Specialist Contracting. For further queries, please see their details below, telephone numbers and email addresses. And indeed, if you have any further queries in relation to COVID clauses, contract negotiations, payment claims, adjudication or business interruption, you'll see my contact details below. Thank you very much.